Hey, I'm gonna show y'all something that I've been kind of dodging this for years now, and I had to, I took a different approach concerning this situation with me trying to get my son back. Most of y'all know my story. You know I'm trying to get my boy back. He is 7 years old now. He was born in 2016, and this is a thing here in Georgia. There's only a few states. I don't know what all states do this, but here in Georgia, they have you don't have rights to a child merely by doing a paternity acknowledgement form. As y'all already know, I did that. I showed that to y'all years ago in 2019 when on my old channel that I had years ago. That YouTube shut down at January 2020? For some unknown reason. I never knew why they really shut it down, but I think maybe because of some of the copyright versions, some copyright type stuff. Like a lot of times I would show people's, say Justia. I don't know. I don't fucking know. But back to the point. But I had to have a moment with concerning all these years I've been fighting, trying to get my son back, and me beating the old case. The old case was not just child support, but it was custody as well. Because I showed y'all in my last video I posted probably about a week or so ago, where there was actually she petitioned the court for my son's mom petitioned the courts for sole legal custody, sole physical custody, child support, and she wanted she did an injunctive relief, because at that point I had my son when she filed it. So that's when I told y'all about that story where the deputy sheriffs came to my house trying to take my son and all that stuff, but they didn't take him, but they did serve me. Okay, that's trying to stick to the point, because I already actually told y'all this story already. So once she took my son, the following week we had the first hearing, okay? And they spent the entire time trying to get me to give them, the financials. So the financials, they had a motion to compel, all this other different stuff in there. For people that like to post my videos, they post like different parts of my old case. You'll see if they want to go and do a whole break down the entire case. You see, I filed a whole lot of bullshit in there because it's my first rodeo show. Never did it before, never went through it before. But I was fighting the best way I knew how to try to get my son. And the whole time they were too busy trying to get. I was playing the name game, like didn't want them to call me Michael Roseman. Didn't want them to call me that. Because I was playing the straw man game. I'm the living man name. I was doing all that. As amateurs, that's what we do when we first learn it, because that's what we hear on the internet. So we don't know how to articulate this stuff in the beginning. Okay. Now, as I was learning over the years, I went across this thing that they call here in Georgia, they call it legitimation. And it's different from acknowledging paternity. What I did in the court, what I did at the hospital the day my son was born, I think it was the next day. I was noticing that they had my son's last name on the little thing that he was laying in, like a little cradle thing, or the little tab thing that they have the name, how much the baby's birthday, the name, and all the the little information about the baby. And I noticed his last name, they had Smith on there. And I corrected the nurse about it, and they gave my son's mother the that look to see if she would get, if she'd approve that we changed his last name to Rosemont. And she gave the nod of approval. Okay, so at that point, later on that afternoon, a notary came in there with a paternity acknowledgement form, and the lady told me that, she told us both that in order for my son to bear my last name, we had to do that paternity acknowledgement form. And we completed it. And my son's last name was changed to Rosemont, Michael Jace Rosemont. Okay. So from that point, I was under the impression that I had legal rights to my son since I did the paternity acknowledgement form, and I'm on the birth certificate. You know, I'm talking layman's terms, so don't y'all get so caught up because I'm saying I'm on the birth certificate. Okay, I'm just using basic information, plain English to explain what I'm talking about. I'm not trying to make sure I watch how I'm talking. This is plain English I'm talking. Okay, so the name was on the birth certificate, and the paternity, paternity from my understanding, paternity was established. That's what I'm thinking. But I'm keep in mind I'm an amateur as I go. And of course, we're all still learning this stuff as we go. So even 7 years later, I'm not a pro. But here we go. I've been dodging because it's not the first time I heard people ask me, have you got your child legitimated? Yeah, and I'm like, yeah, that was already established at the hospital. And I stumbled across statutes here in Georgia, learning the laws the way they do it here in Georgia, is that you have to go further than just doing a paternity acknowledgement form. They have a thing called legitimation. You have to do a legitimation process where you actually go through the courts. You go through the courts, you do a petition for establishing paternity as opposed to acknowledgement of paternity. And me not understanding, I think a part of me just didn't want to accept the fact that the paternity acknowledgement form wasn't enough. I didn't want to accept it because I was in my mind, it was like that's a trap going through the legitimation process, because they do it through the courts and automatically you locked in for child support. You agree to it automatically if you give them DNA. Okay, so this is my mentality. And which is why I took a different route going through this second case. I decided to try it because I've been studying some other stuff that I don't talk about on the internet. In short, I'm studying about tendering. Okay, and I'm gonna leave it like that. I won't be making videos about how to do it properly. I won't do none of that. Okay, but that's something you do on the private side. Okay, but let me stick to the topic. So all these years I've been, using, the paternity acknowledgement, thinking that that's supposed to give me, legal access to be able to file for custody and all those different stuff. I shouldn't have closed my damn screen either. I should have left that screen open so I could read that part to y'all too. But I might go do it anyway, but I'm gonna show y'all what this thing says that I found here in that what I've been really dodging. I didn't want to accept the fact that in order to claim custody, it's not enough to just beat a child support case, because child support ain't the biggest issue. I want my son back, okay? I want my son back. And it's just not enough to just beat a child support case. I want to be able to have access to him so I can father him. I want to be able to, have a relationship with him. And I ain't talking about no every other weekend, like the courts like to screw fathers with that. And because their family court is all about money. They don't give a damn about the children. They don't give a damn about if you ever have a relationship with your children. They don't care. The child never meets you. As long as they can get a paycheck out of the deal, that's all the fuck they care about. And because even in my new case, I filed an answer to the case, and I was specifically talking about the fact that I haven't seen him in 7 years, and that his mother has kept him hidden from me all this time. Now, come next year, he'll be 8. In June, he turns 8. And I'm sure some of y'all know that a child support order has been filed into my new case. And it's only $264. So anybody try to poke fun of a $264 child support order, it's crazy. But bottom line is that I'm looking at it as an opportunity to do the things that I've been basically satisfy the financial aspect of it. And we've been given things. We've already been given things. Things have already been put in place for us to use to settle the financial aspect of things. I don't want to say too much, but we already have the tools, but we don't read enough. Now, if you back up this video and you hear what I said about 2 or 3 minutes ago, you can put that with what I just said, and you'll get what I'm talking about. So it's like once you conquer the financial aspect of things, and see that I was really trying to dodge being put in a situation where the state, these child support agencies do some of the low down dirtiest shit to the fathers if they happen to drop the ball for whatever reason. I wouldn't drop a ball with a $264 payment any fucking way. But just all these years I've been kind of dodging that situation, dodging being put in a situation because of the people I've talked to. I know what's happened to everybody I know. Everybody I know personally and people that I've met on the, from YouTube, all the fathers, the hundreds of fathers that I've talked to. I've talked to so many of them, and all of them get handled some type of way. And fathers get treated like shit when it comes to our children. And it's on a ridiculously large scale. And I found that being more of my focus is making sure I never get put on child support. So that was my goal, and I kind of lost. I kind of got sidetracked. Put it like that. Got sidetracked on my ultimate goal, which is seeing my son. I even thought about I've known some people to even got your LLC that's not in your name, and you whatever. I've known people to create LLCs just so they can actually have them. They can have their straw man working for the LLC and making minimum wage just to keep the shit down. I know people who've done that. So personally, I've known people that done that. So how can I say this? I was running from this legitimation shit because I didn't want to get caught up in the child support scheme. I didn't want to get caught up in the scam altogether because, probably because we make it so much of it's such a big deal on the internet till it's really a curse in a lot of cases. Only if you don't know what to do about it. And just because you got a child support order filed into your court case doesn't mean that the case is over. Okay. Try not to say too much. So I've come to this conclusion. I thought I'd go ahead and revisit this legitimation. And this is what I'll show y'all. First, I'm gonna show y'all where I got it from. I typed this in here, establishing paternity and legitimation. It's Georgia law right here. Okay, so all I did is click this here and got this PDF. Make it bigger so y'all can see what it says. Okay. Georgia law has 2 ways of recognizing the relationship between a father and a child: paternity and legitimation. This is what I did already. I have not done this. Georgia is one of the few states that has an additional layer of legitimation. Okay, this is a part of a continuum to establish custodial rights. Custodial meaning having access, having custody of the child. So okay, say paternity, legitimation, custodial visitation rights. Administrative process. Let's read this here. I haven't even. This is my first time reading this actual PDF. I actually read the law, so most likely it's going to explain the law in this PDF. So hopefully I don't have to open no other pages, no other stuff. Paternity. Under Georgia law, paternity establishes the biological condition of being a father, but does not establish the legal relationship of the father / child, the father-child. Superior and state courts have concurrent jurisdiction in paternity proceedings. OCGA, that's the code. Paternity cases are not subject to a jury trial. Say who may establish paternity. Say when parents are not married, a petition to establish paternity of a child may be brought by the child, the mother of the child, any relative whose care the child has been placed, the Georgia Department of Human Services, which is the company, that's the actual company that brought a case against me recently, okay, in my new case. So in the name of the child, and for the benefit of the child, for whom the public assistance is received, or in the name of, and for the benefit of the child, not the recipient of public assistance whose custodian has applied for services for the child, or one who is alleged to be the father. That would be me, okay? Now, so they say I may establish paternity. So, which is what I thought I did at the hospital, because I did a paternity of acknowledgement form. That's probably what they're going to talk about here. That's probably what they're talking about right here, but I'm going to start right here and read it all from the top to the bottom. Evidence of paternity. Evidence of paternity is the appearance of the name or social security number of the father, entered with his written consent on the birth certificate. Well, the social security name is not on there. There's not social security number on there, but the appearance of the name. Notice they say the appearance of the name. It didn't say proper style, it say appearance. But we're gonna stay on topic. And it say with consent of the consent on the birth certificate. This shall constitute a prima facie case of paternity establishment. The burden of proof shifts to the father to rebut such in a proceeding. Now, I did this already. My name is already, the appearance of the name is on the birth certificate. Okay? Administrative paternity acknowledgement. It says that the father can administratively acknowledge their biological relationship with the child. Say fathers can administratively acknowledge their biological relationship with the child. The paternity acknowledgement form may be completed at the hospital at the time of the birth of the child, or later at the Georgia State Office of Vital Records. Further, the form must be signed in the presence of a notary. The form filed with the Georgia State the Office of Vital Records. Okay, we did that. That's what we did at the hospital. Okay, by completing the paternity acknowledgement form, the following benefits occur. The biological father's name gets added to the child's birth certificate. Financial support may be received from the father. The child may be eligible for Social Security benefits from the father. That's all it says. Let's see. What is the purpose? Say what is the purpose of going through the voluntary process? It is used to add the father to the birth record. Because keep in mind, y'all, remember I showed y'all in previous videos, my son's birth, my name is not written nowhere in his birth, his medical records at all the day he was born. So I'm not even written nowhere on there, okay? He had his mom on there, his grandma was on there, but I was nowhere written on there. Even though I witnessed his birth, all three of us were there, okay? It can also be used in furtherance of effort to legitimate the relationship between the father and the father and child. See, that's what was not done. It's a furtherance of efforts. Anyway, it is also a low-cost method of furthering the process of establishing father-child relationship. Okay, note the father's name gets added to the punitive father registry only when the father also submits a punitive registration form to the Georgia State Office of Vital Records. Okay, the punitive father, administrative determination of paternity. So if a child support agency seeks to establish paternity through the Office of Administrative Hearing, OSHA. I'm gonna say OSHA. OSHA shall have the authority to adjudicate paternity pursuant to Chapter 13 of Title 50 of the Georgia Administrative Procedure Act. However, the putative father may demand a trial in the superior court. The administrative determination shall have the same force and effect as a judicial decree. Okay. Child support. So whether a man has been adjudicated by the court or voluntary acknowledgement paternity, which is what I did, through the administrative process, he shall be legally liable for support of the child in the same manner as he would if the child was born of a marriage. Okay. This is one reason why most people don't want to be on the birth certificate. They feel like they're automatically locked in there. They have to go through the process first to get it done though. But anyway, here we go. Legitimation. In Georgia, legitimation allows the biological father, to be recognized by law as the legal father, and when the child is born out of wedlock. The superior and juvenile courts have concurrent jurisdiction in legitimation cases. If there is a demand by either parent for a jury trial as to child support after a petition for legitimation has been granted, then the case shall be transferred from juvenile to superior court for such jury trial. That's the Georgia law. You'll see where it's written right there. Administrative acknowledgement of legitimation. The acknowledgement of legitimation section is on the bottom of the paternity acknowledgement form. In the legitimation section of this form, the voluntary declaration may be made that the mother and the biological father consent and agree that the relationship between the child and the father shall be considered legitimate for all purposes under the law, according to OCGA. That's the code right there. I don't know if I might need to go back and look at that, but I'll go back and look at that later. Okay, I read that before I pushed start. I remember that. If both parents freely agree and consent that the child may be legitimated, both the mother and father signatures are required. The signatures must be notarized, and a photo identification is also required. Signing only the top section of the form pertaining to paternity acknowledgement does not constitute legal determination of legitimation. See right here? Say signing only the top section of the form pertaining to paternity acknowledgement does not constitute legal determination of legitimation. The form, which is actually called the paternity acknowledgement form, is filed in the Georgia State Office of Vital Records. Also, let me see. Also, right here, I might need to go look at that so I can show y'all what that form looks like. I think they changed the way the form looks like since my son was born too. They changed it the same month, June the 30th to be exact. My son was born June 8th. Okay, let's see. Safeguards with the voluntary legitimation acknowledgement process. Voluntary acknowledgement of legitimation must take place prior to the child's first birthday. Both mother and father must freely agree and consent. The legitimation section of the paternity acknowledgement form cannot be signed if the mother is married to someone else, or was married to someone else at the time within the usual period of gestation, or there is another legal father. Say the form can also be signed if the mother's rights, if the mother's rights have been terminated, or the mother has signed a form with another man. Further, by making a false statement on the acknowledgement form pursuant to Georgia Code, penalties include prison term of up to 5 years and monetary fines up to $10,000. For y'all that have been victimized, with some paternity fraud, y'all might want to look at that. Okay, because I know a lot of guys get got with that too. Okay, let me see how far this goes. Okay, let me get on back up here. Let me see. Determination of paternity legitimation. A paternity and legitimation have not been established through voluntary acknowledgement process. Say if paternity and legitimation have not been established through a voluntary acknowledgement process, a single petition for paternity legitimation may be filed anytime after the birth of the child by the father, and include claims for visitation, parenting time, or custody. This is what they're talking about right here. Okay, let me keep going. Say who may file legitimation? Only the biological father of the child may file a judicial petition seeking to legitimate his child. This is what I have not done. The petition for legitimation may also include claims of visitation, parenting time, or custody. Say if the Department of Human Services, Division of Child Support Services, files a petition to establish paternity in the name of and for the benefit of the child for whom public assistance is received, or whose custodian has applied for services for the child, the alleged father may assert third-party action for the legitimation of the child. Say where to file legitimation petition. The petition is filed in the county of the resident of the child's mother, or the party having legal custody or guardian of the child. Let's say if somebody adopted the child or they got some foster parents or something. However, if the mother or other party having legal custody or guardianship of the child resides outside of Georgia or cannot be found within the state, the petition may be filed in the county of the father's residence, or the county of the child's residence. A legitimation petition may be filed in the juvenile court of the county in which a deprivation proceeding regarding the child is pending. Okay, this is what I needed to be doing the whole time, y'all. Say if there is a pending petition for adoption of the child, the father must file the legitimation petition in the county in which the adoption petition is filed. Okay. Let's see, legitimation. Okay, the requirements for legitimation petition. The petition shall set forth the name, sex, and the same name, age, and sex of the child, the name of the mother, and if the father desires the name of the child to be changed, the new name. If the mother is alive, she shall be named as a party, and she shall be served and provided in opportunity to be heard. There's a code that backs that up. Contest of legitimation. The mother may contest. She may contest the legitimation petition by alleging that the petitioner is not the biological father, or that he has lost his opportunity interest, and that's a whatever. That's the case law. Okay. Let's see. Well, she can never say that, because I've been fighting for him the whole damn time. So, declaring in order of legitimation. Upon the presentation of the and filing of the petition, the court may pass an order declaring the father's relationship with the child to be legitimated, and that the father and child shall be capable of inheriting from each other in the same manner as if the child was born lawfully in a lawful wedlock, and specifying the name by which the child shall be known. This is what I have not done, y'all. This is exactly one of the main reasons I fought so hard and been unsuccessful with getting this done when it comes to my son. Now, part of legitimation, they actually require y'all to submit DNA samples. I'm gonna keep on going. I'm gonna read the rest of it first, and then I'll go to the rest of it. Okay. Determining custody and visitation. A father shall not be authorized to receive custody or visitation until there is a judicial determination of custody or visitation. Custody of the child shall remain with the mother unless or until the court order is entered addressing the issue of custody. Genetic testing. In any case, I was jumping the gun about to talk about it. In any case in which the paternity of a child or children has not been established, any party may make a motion for the court to order the mother, alleged father, and the child to submit genetic tests. When the Department of Human Services brings a petition, when the Department of Human Services brings a petition to establish the paternity of a child, issues of name, visitation, and custody shall not be determined by the court until such time as a separate petition is filed by one of the parents or legal guardian of the child. Say if the petition is brought by a party other than the Department of Human Services, the court may determine issues of name change, visitation, and custody. So this same case that I have going on, this is where I'll be filing my petition at. Okay, so I'm trying to get at the end of the day, I'm trying to get access to my son. So more people, making a bigger deal about child support than they are actually having access to their kids. And I don't want to settle for the every other weekend, every once a month, the supervised visitation like I'm some child molester, some shit. I never want to settle for that. So I've been wanting 50-50, but at the same time, we're going to see exactly what's going to go with what I'm doing now. Okay, but I do see that there's no way around here in Georgia. There's no way around doing a legitimation process if you actually want to have access to your kid. If you actually want to raise your children and will actually have some say so, you got to go through this. It's more. You got to do more than just doing a paternity acknowledgement form. But I'm gonna keep reading. The disestablishment process. The specific legal steps to disestablish paternity legitimation are voluntary rescission. If a father signs a paternity acknowledgement form, he may rescind that acknowledgement within 60 days of signing it, unless an order has already been entered establishing paternity. This action will remove the father from the putative father registry, but a court order is required to remove the father's name from the birth certificate and change the child's last name. Where the paternity acknowledgement form is timely rescinded and includes an acknowledgement of legitimation, the legitimation shall also be deemed rescinded. Okay, challenging a paternity acknowledgement after 60 days, but prior to the entry of an order. So after the 60-day rescission period specified by law, the paternity acknowledgement may be challenged in court, but only on the basis of fraud, duress, or material mistake of fact, with the burden of proof on the person challenging the acknowledgement. So I've known some states where say some people just add somebody to their name to the birth certificate some type of fraudulent way, and they don't know how the hell they got it done, but they got it done. And if some people just know notaries personally and they get shit done like that, and a notary can get in trouble for that shit. But anyway, but you got to be willing to assert your rights when it comes to stuff like that. The legal responsibility of any signatory, including child support obligations arising from the acknowledgement, may not be suspended during the challenge, except for good cause shown. Okay, so you gotta really assert your shit, because y'all know these folks try to keep your ass on child support, even when you prove that you ain't even the father's child, the father to the child. They'll still try to keep your ass on child support. But anyway, that's another topic. Motion to set aside. That's Rule 60 I've been telling y'all about. Okay, Rule 60. If you look up Rule 60, you'll see it. There's a motion to set aside a judgment or order, or motion for relief. It would depend on what state you're in. That may be what they'll call it. A motion to set aside a determination of paternity may be filed in a superior court at any time upon grounds set forth in OCG. That's the code. The motion must have attached two essential pieces of proof to show that the person ordered to pay child support cannot be the biological father. As y'all see, remember I told y'all before, when you use a motion, you need to have evidence attached to it. That's what it said. The motion must have attached it must have attached two essential pieces of proof. Two essential pieces of proof to show that the person ordered to pay child support cannot be the biological father. And this is the two pieces of proof they're talking about right here. An affidavit showing newly discovered evidence about the paternity and results of the paternity genetic test conducted within 90 days before the motion is filed. Filing the motion in itself will not necessarily result in disestablishment. I guess you got to go. Also, that's something else. They be trying their best to keep that damn fraud going. They be on some real bullshit. But you got to make sure you stay on that shit, and you probably you may have to. I would try to get a hearing set too. That way you can be heard in a hearing, and then you bring your same. You only gonna go there to be so they can hear your evidence in an open setting. Okay, so you don't just file it and say hope they're gonna do something for you. They probably want. Anyway, extraordinary motion for a new trial. This motion can be filed at any time. The person who files it has to prove the following: when the evidence of non-paternity came to his attention, he acted with appropriate speed to investigate it. He was unaware of the non-paternity before the order was issued, and he could not have known about his non-paternity even if he had acted carefully and reasonably. Filing the motion in itself would not necessarily result in disestablishment. So you got to assert your rights. That's a motion. That's what they call it, a maxim of law. He who fails to assert his rights have none. So you got to stay on it. You can't just file it and just wait for them to do something. I will be trying to get a hearing going so you can get them to move more than just you just filing and just sitting there waiting on them to do something. I know people do that a lot. Okay, so what I did was did the paternity acknowledgement form, but I have not gone through the legitimation. Now, with that being said, I went through the once you learn how to master the financial aspect of these things, when it comes to financial debts, financial obligations, then this type of stuff right here, legitimation, shouldn't be a problem to you. This is where my focus is at. And so I'm trying not to say too much. So just expect something big to take place very soon, extremely soon. But even when it takes place, it's going to be private. What I do private, it won't be filed in a court case. It won't be filed in a court case. It will not be put on the internet. It's going to be completely confidential. So, so I won't be, just expect something big when it comes to it. We have to learn how to use what's already put in place to get you to discharge your debts. HJR 192. I'm going to leave it like that. Okay? If you haven't liked and subscribed already, go ahead and do so. And we'll see y'all in the next video. Emeralds signing out.